Okay, do we have agreements on the MTRPs?
Yeah, well, I mean, it's 2 years, so we're letting you decide on that. He's pleading true to it. I mean, it's up to 2 years.
Okay, but so what do we do about whatever I do? He has a right to appeal. I mean, practically, we know what's going to happen. I mean, he wouldn't, but still, there's no paperwork that reflects it. You don't, the parties don't think we need that. I mean,
Well, paperwork to do for it.
would be just one document.
No, it's not 4 documents, one on each case. Or it's just let you.
No, on the waiver. It depends on what you want to do. Do you waive, does he waive appeal or not on those?
Do you want to appeal these?
You know, he knows what he's going to
Yeah,
get.
he knows, yeah.
I mean,
Yeah, I don't think
there's been a handshake that I'm going to follow.
Right. We all know what's going to happen and he's okay with that. It's part of the agreement. You can, do we need to do, is there a waiver? We can just do a handwritten waiver? Yes. Versus doing it all with tablets.
There's just nothing, there's nothing in the record that shows it. I mean, it's still do it.
Yeah. Yeah, if he appealed it, it's all invalid anyway. It impacts him.
What do you want to do? Nothing?
I don't think he's gonna, he's
All right.
gonna appeal and follow
We'll
those.
still appeal.
If you do, then it's kind of all this is. Yeah. Yeah, it'd be the worst thing you could possibly do. Yeah.
Now I wanted.
But it just,
It's a bit full of that, so, yeah.
I kind of have it just, has something that reflects a memorialization of what's going on
Yeah,
here.
we believe he has enough time to cover it anyway. So with all his backing up and all that, so I don't think he wants to appeal it. He wants to be done with it. He's a little bit. And then on the new case, he can't appeal because he signed his waiver of appeal. So.
All right. We're going to take up the 4 motions to revoke probation first. And then we will handle the new case.
Yes.
And you are Sindjin Trent Mallard. And raise your right hand, sir. Do you solemnly swear or affirm any statement you make during these hearings will be the truth, the whole truth, and nothing but the truth, so help you God? So lower your hand, sir. In '22 39761 and 23 CR 680 and 23 CR 681 and 23 CR 682. Motions to revoke probation have been filed in your cases. Does the defendant waive formal readings of these? Can we proceed in summary?
Yes, Your Honor.
And in 39761, 60 and 681, as well as 682. These motions to revoke probation, which are in 39761, 680, and 681, second amended motions to revoke probation, all filed on September 30th of 2025. And then the 23 CR 682 is a first amended motion standby. There's a second amended that was not that I've just found.
Yes.
They're all second amended motions. They're all second amended motions to revoke probation that are dated September 30th, 2025. They similarly allege in each of these 4 cases that on August 7th, 2023, in this criminal district court, you were sentenced to 2 years in the state jail, and that was suspended, and you were placed on probation for 5 years in each case for theft of material, and this is metals in 22 39761, in 680 burglary of a building, in 681 burglary of a building, and in 682 theft, the state jail felony. And again, you were placed on probation on August 7th, 2023 in each of these 4 cases. Is all of that true and correct? we're gonna do is just use one that should reflect the new case.
That's what I was gonna suggest, Your Honor. Yes.
If it's in there. Burglary and it's not in there.
That one.
God bless it.
So then, which, and all of it, one of them.
Is not in these are all non-substantive allegations.
Let's take one of the
Which
most
is
recent, administrative violations, then, 'cause I think
All
we're
right.
ready here.
Then try this one.
Yeah.
In allegation 7, in each of these four motions, amended motions to revoke probation, number 7 similarly alleges that you failed to report to the Jefferson County Probation Office for the months of August, September, October, December of 2024, and January, February, March, April, and May of 2025 in violation of your probation order condition 4, which requires you to report monthly as directed. Is that, are those allegations all true and correct if they are alleged? So are you pleading true to those allegations, the same ones, number 7 in each case, true and truly and correctly, and because it is an accurate allegation?
Yes, sir.
So what happens is he absconded and you quit reporting. And then when were you arrested?
September 5th of 24.
You understand that one or more violations of probation proven true by a preponderance of the evidence or greater, that's all it takes to revoke your probation.
Yes, sir.
Your probation could be revoked and you could be sentenced up to 2 years in the state jail, no less than 180 days, up to 2 years in the state jail. Knowing that, do you insist on pleading true nonetheless?
Yes, sir.
In each case.
Yes, sir.
This is a lost cause in person. I don't know if it is for that. Yeah, well, yeah.
Is that enough for everybody?
Yes, sir.
Okay.
It's also important.
There are other violations, but
Everything you can.
you understand the consequences that can apply. This, you're voluntarily and knowingly made plea of true to absconding, that is not reporting for August of 2024 and each month through May of 2025, which is almost a year, a block of a year, is all that is required for this court to find by a preponderance of the evidence or greater it true, and that those allegations are true in each case, and that is enough to revoke your probation, sentence you up to 2 years, no less than 180 days, up to 2 years in the state jail. Do you understand that thoroughly?
Yes, sir.
And you insist on pleading true nonetheless?
Yes, sir.
I find you are pleading true voluntarily. You understand and appreciate the consequences of pleading true. Here, there's no written agreement. Okay, what do parties want to say?
You know, for the record, my client does waive his right to appeal. That on the record, that's an issue.
I'm
Yeah.
gonna have that signed if you
That's
don't
all,
mind
that's no
here
problem, yeah.
later on.
Yeah.
We'll memorialize that with a signature, okay?
But otherwise, we did let the court decide the much in this case. We've got a deal worked out where the new case will be getting probation, and we'll leave it up to the court to decide this punishment.
Okay.
General, we'd ask for the full 2 years on this. I believe he's probably almost got time served on it.
You know how much Well, y'all know. You know.
Yes, yes.
14 months.
Almost.
Oh,
The prior.
He's got more than that. I think he's got 14 months now currently with now, but he's also got time for 4.
We didn't have.
And have a hole when he was in,
They didn't do, we didn't have the warrant on the NTRP until.
Until January, I think, is whenever y'all MTRP'd me. When I was in Orange County. Cause y'all MTRP'd me.
well, that's,
Going back to why I left.
well, that, I think that just doesn't make,
Until September. Okay.
that doesn't make sense because we filed motions to revoke probation in February of 24. The beginning, then there was a second amended, I mean, a first amended, then there was a second amended. So something had to have been done on that first motion, so you should have been held.
Yes.
So that ought to be,
right, he gets other time.
September.
He's had a bunch of different periods, various periods of time that add. It's not one continuous period of time, but yes.
you understand that's going to have to be calculated, but you will be given credit for all the time I logged you have served in accordance with this matter. Did you want to add anything, sir, on that? Anything else?
Not trying to.
Then I find there is sufficient evidence supporting these second amended motions to revoke probation in each of these 4 cases, to grant the motions by a preponderance of the evidence greater in each case is allegation 7, failing to report to the probation office for a block of a year from August through May, August 24 through May of 25, and essentially the defendant absconded until he was finally arrested later on warrants because of the motions to revoke probation. And thus your probation is revoked in each of these cases. You were sentenced to 2 years in a state jail, probated for 5 years in each case. You are hereby sentenced to confinement in the state jail for 2 years on each case to run concurrently on each of these 4 cases. Do you understand what has happened today? Then I have a new case, 24 CR 1681. Does the defendant waive a formal reading of this? Can we proceed in summary?
Yes, sure, please.
In summary, Mr. Mallard, this indictment alleges that on or about February 12th, 2024 in Jefferson County, Texas, you committed the state jail felony of burglary of a building. Do you understand what you're charged with here?
Yes, sir.
If convicted, you face no less than 180 days up to 2 years in the state jail, and a fine up to $10,000 can be assessed. Do you understand?
Yes, sir.
This is similar to those other state jails in punishment. An agreement's been reached in your case where you would be pleading guilty, sentenced to 2 years in the state jail. That would be suspended. You would be placed on regular probation for 5 years. You would be ordered to pay restitution in the amount of $34,723. And this says in 2 cents. I have got a different figure on that, but it's right at that. I thought it was 34,722 and 93 cents. You're showing we're 9 cents off, but we're going to round that to $34,723.
Yes,
Okay,
sir.
is that agreeable for everybody?
Change matters.
All right. There will be terms and conditions of probation which are normal and customary for this. If you fail, your probation could be revoked, just like that can happen. And then you could be sentenced to another 2 years, which just get these people taken care of. Do the right thing. It's just morally and legally the right thing to do, and it'll make you feel better.
So,
but these people need to get paid back. We're gonna go into the record, each of the victims and how much they owe. Did you do that, yes, ma'am? Okay, I go on. I think we had a calculation for each one that we'll read into the record. So again, Mr. Mallard, how do you plead to this indictment? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty? Show you what's marked as State's Exhibit 1, John?
Yes.
Did you sign that document voluntarily, understand it, discuss it with your attorney, or the content fall through incorrect? Yes, sir. State's Exhibit 1 tendered into evidence.
No, yeah.
Without objection, it's submitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been brought to you. You've read it. You were guilty of the crime charged and any lesser included offenses. You were giving up your rights to a jury trial and your rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All true. It states so help you God. Yes, sir. States Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, please.
I'm going to follow this agreement, if nothing further, and find that you are pleading guilty, sir, voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea. The State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. I find you guilty now beyond a reasonable doubt of your state jail felony of burglary of a building. I am following this agreement. You were hereby sentenced to confinement in the state jail for 2 years. That will be suspended. You were placed on regular probation for 5 years. You shall pay a restitution in the amount of $34,723. And it will be in the following way. It will be to stand on. $8,683 and 9 cents is ordered to the victim Norbert Romero. And that was from an earlier case, 39761. Additionally, restitution was
17,700, Your Honor, from 0680.
$17,700 to Samuel Massey IV,
Yes, Your Honor.
the complainant out of 680. And then an additional amount of restitution will be
Last time.
$2,000,
Yes,
right?
Yes, Your Honor.
To
0681.
James Worthy from 23 CR 681. And
$2,633.34 from
$1,633.34
0682.
will be to Gordon Ricassa, RICOSSA, the complainant victim in cause number 23682. And then the only other one is,
For this current case, Your Honor.
is Dale Rogers
Yes, sir.
in 1681 that you have pleaded guilty to, and that the other restitutions will be part of, and that's $3,706.59.
That's correct, Your Honor.
Which totals out to about $34,723. What I have that. So your work is cut out. Do well on this, and it's the right thing to do. So pay these people back.
for their loss. So, do you understand what has happened today, sir?
Yes, sir.
Let's look at it. We're getting now.
Anything else to add, John,
Nothing less.
from probation?
I had. Yeah.
You'll take that you.
Here's this one.
Thank you.
Okay, we've got this, there we go. I think that's covered all that restitution, the way you're doing it. I think the right way to do it. Yes, ma'am.
Raise the money.
Thank you very much. John, anything else on this?
Not on this one, Your Honor.
Fine, put in here now. He heard this one. This come the same thing he actually did. They did have it. You can tell.
We're getting the wires cramps here.
Get out of it.
These are going to be all these additional terms of probation, which are the restitution matters. There's additional documents, but they're all of for each of those cases where the restitution were unique and different that we're putting together in a compilation for this last case to get the people paid back. That's what those additional papers on. What did I miss on that, John? Anything at all?
I think.
Thank you.
And.
Oh, sorry.
I say, Jason,
What do we have left?